We are live.
All right, welcome to the House Judiciary Committee this Friday morning, January 16th. Only have a couple items this morning. Some of the things are now off that were originally scheduled. We're not going to have additional testimony on the animal cruelty bill from the state's attorney from Windham County. We're going to reschedule that for later. Some conflict came up where he can't make it this morning. And also we're not going to take up H5. That's going to be hanging on the wall. It's not dead, but not ready, really not ready for votes. And folks need some more time to ponder that one. So I do want to have a straw poll on H545 on the one section that we dealt with. And then I want to talk just a little bit about the next revised version that we did have some conversation the other day, but wanted to hit on a couple additional items on what we're going to actually ask Eric to work on for the next version of that bill, of the animal cruelty bill. But starting with H545, we have fairly narrow jurisdiction or fairly narrow question before us. And it really has to do, and I'm looking at the bill, and I'm looking at draft number 2.1, and specifically section 2, which is 18 VSA 11, section 1130A, and in particular subsection C in that. And it has to do with immunity. The reason I kept on messing up is it's immunity for immunization. So of course I had trouble with that. So it's an immunity section for the healthcare professionals who prescribe, dispense, or administer immunization according to the recommendations that are in subsection A of this provision. And the immunity is that as long as they are following those recommendations, they're not going to be liable unless there's gross negligence, recklessness, or intentional misconduct. This doesn't deal with any kind of liability that the state may have as far as making the recommendations. That's not before us. It doesn't have anything to do with liability of pharmaceutical manufacturers, which under current law is there's a federal law that preempts us from doing anything in that space. If that changes, maybe we'll see another bill sometime down the road, but that's not part of this. Also, as I understand from the testimony that we had yesterday, that this is really about clinical recommendations for immunizations. It's not where there's any kind of mandates or anything like that. It's just what are clinically recommended by the evidence and the science as our state reads it. So with that, I'll go ahead and take a motion and then we can have further discussion. But I guess the motion would be that we don't object or that we are fine. I mean, that doesn't sound very formal, does it? Yeah, we're fine with so moved. I should have thought over exactly what the motion sounds like.
Recommend finding it favorable?
Yeah, we recommend, no, we don't recommend finding the whole thing favorable because all we are looking at as part C, that the committee has no further comment and agrees with subsection C. All right. And second. Any further discussion? Anybody? Yeah, go ahead.
Yeah, I don't have a problem with what we're doing. I mean, we've passed legislation in the past that, protected our healthcare workers around, to me, more controversial topics. And I just think it's important to protect our healthcare community because it's like all industries or all jobs or whatever, and not just Vermont, but a lot of different places. The number of people that are doing it is shrinking, and I just don't think we can afford to lose any more healthcare professionals or plumbers or electricians or anything. So I'm fully in support of supporting them.
Okay. Any other discussion? All right, seeing none, all those in favor of finding subsection C favorable, I guess that's how we're good. Raise your hand. All those opposed? So that is 8-1.
8-1.
And I will, if we have to report or do anything on the floor, which not necessarily that we will, I'll go ahead and do it. All right, that's all we have on that. So if folks can kind of stick with me for just a few minutes to look at the animal cruelty, and I had one particular. So
Where did you count my vote?
as a no, is that a
No, I
no?
mean, I was just late raising.
Oh, okay, so it was 9-1-1. All right, fine. Sorry. Gotta be quick around here, I guess. So the committee went over kind of a number of things that we're going to change in for at least the next revision for everybody's consideration. One place that we didn't really land on what we thought we should at least consider, and again, this is just to move this along, and we will have further discussion about these changes once we have it. But I just wanted to I've been giving some more thought about this, and I have a proposal that I want to put in language, but we can discuss that now, or we can discuss it when we see the language. And specifically with the may, shall, and a number of us had some problems, as we also heard from Judge Zone, with having the shall language, and this is on page 8. I'm looking at the bill on page 8.
Which?
And this is, bill is introduced. And the issue is that with a couple issues, with the shall language, it takes away the ability for defense counsel, prosecutors to negotiate agreements to resolve these cases through plea agreements, and thus a lot more cases may go to trial, which is certainly something we would rather avoid given the backlog and such. So it also doesn't reflect the individual situations and the individual offenses. I mean, not to point out one that seems unlikely that it will be prosecuted, the selling or displaying a living baby chick, duckling, or fowl that's been dyed, colored or otherwise, that's actually an offense. You can that's a misdemeanor animal cruelty offense.
Now?
That's right now. So I'm not sure where that came from, but forgetting that one, but there could be individual situations where there should be some flexibility. So what I'm going to propose that we have for the next version is that for a first offense misdemeanor, there can be up to 5 years of a ban on possession. And it would be May. It would essentially be May for first time. And also, it would be essentially May for everything that the court can impose, but we would add that you can go up to 5 years. If it's a second or subsequent, it would then become a shall, that you shall forfeit the right to your animal, and you shall be prohibited from having an animal for a minimum of 5 years, and it could be longer. So that would be what I'm proposing that we take a look at least for misdemeanor.
So the second offense, obviously stiffer, but there would still be the chance to redeem yourself and own animals.
Well, I mean, after 5 years.
Right,
or
right.
There's the other, well, I'll get to the other possibility in 1 second as far as whether we want to have this other language. But let me just finish on the felony. I was thinking essentially the same thing. First offense, up to 10 years, may, lose your animals for up to 10 years. You may forfeit your animal. If it's a second felony, it's a mandatory minimum essentially of losing your animals for a minimum of 10 years.
In 10.
Yeah. So the additional part that I would maybe suggest that we take a look at and have it drafted and consider it is an opportunity for an individual who has a long ban on possession that they can move the court. Like they can say, I've taken animal cruelty, I've gotten help.
I know what you mean, yeah.
Yeah, and can actually move the court to get rid of the prohibition. So I think there's some draft language in another state that I'm gonna, I'll ask Eric to just have out there for us to consider. Again, we'll have the testimony and we'll decide whether we want to go with it. But I thought, at least for this next draft, we should do that. So that's the main one that we hadn't really landed on anything for the next version. And I guess there's anybody want to comment on that, or
So can you just repeat, you had two shells for the second offense. One was the lose the animal.
yeah, and the right to possess or own or work with or or
Okay,
reside with.
not anything with the jail time.
Not
Okay,
right, it's not, this is all just the ban on possession of animals. And I wouldn't do a shell for the repaying the costs or the participating in available animal cruelty or permit periodic, that would all remain made throughout, because that, I think you need a lot more flexibility on those.
sounds good.
So, I mean, and we'll have testimony, like I said, we'll have testimony, we'll have discussion on, it, but I wanted to flag that I thought that at least that'd be good for the next version. Any
Yeah.
thoughts on that? Are we good with just trying that?
Yes, I support that and appreciate you doing the work to come up with some language so that there are many options.
Yeah, I think
Yeah.
it strikes a good balance between the two. And like just because it's shall like or may language doesn't mean that in a circumstance they could impose just as strict of a consequence as the shall language or the first.
Yeah, I like the redemption part. I mean, even with the second offense, get into the third. It's not so much gray area there, I guess, for me, but and the thing that goes through my mind with redemption is there's people who have their children taken away. And if they have another child, they have their children taken away for probably going to be much more serious offenses than this. But if they have another child, they'll be able to keep it. So that, in a sense, that's kind of redemption, I guess you could say. But I just think the redemption part is important.
Great.
People deserve a chance.
Sometimes they can't keep their subsequent child.
Sometimes.
Right. Sometimes.
Yeah, the
right,
redemption may not always happen, of course.
Right.
Yeah.
So it's an opportunity. So the last thing I just wanted to mention, one other thing for another bill, which is on a longer runway, which is the voter intimidation bill. I've talked to some people about this, but I wanted everybody to kind of know where this is. So we found out, all right, so we had testimony from the Defender General and the Chief Superior Judge on a section of the bill, which wasn't the heart of the bill, frankly, for civil investigation. There's language about a civil investigation, and Matt Valerio and Judge Zone had multiple issues with it. Come to find out, that same language is in S23, which is in front of the GovOps committee in the Senate. S23 has gone to the House, we've amended it, and we've sent it back, and they're looking at our amendments, and yet, the civil suspension stuff is there. And so I ran into Senator Collmore, chair of the committee last night, and he's like, oh, by the way, we had some testimony that has some concerns on that. But here's kind of where I suggested that we land on that. I think Senator Collmore agreed, is that same language is from another section in Title 17 that's been there at least since 2017. I didn't do the deep research to see if it's even older than that. And apparently it hasn't been a problem. The problem is that maybe it's just because it hasn't been litigated yet, but it was like, all right, just go ahead with S23, leaving that in there. We're going to take it out of our bill. And I'm putting in a bill drafted, my first for 2027, if in fact South Burlington will have me back, that will do what we talked about in here, which is consolidating all of Title 17 civil investigations into one place and addressing the concerns that we heard from the Defender General. Yeah. So the other thing I'm planning on doing is taking kind of what we heard, and I'll talk, Ian and I will look at this, taking what we learned from the testimony and looking at our Title 13 and our language here, and is there some additional, we're going to try to do a new draft that try to addresses some of that, and I'm going to reach out to President Smola to see if he can come in and testify on this, maybe as early as next week, but I'm going to try to ask them if it's even worth or if it's so clear that we can't do what we're suggesting. So anyway, I'm gonna reach out to him and maybe we can move that one along one way or another or kill it in the next week or so.
Can we get the ACLU in next week too? Because I know.
Yeah, they yes.
Okay.
I reached out to Falco and he was going to be testifying yesterday. I'm glad that we postponed it because it would have been after the garbage, which that would have been tough. But also I just said, we're gonna have a new draft and wait until we have a new draft.
Yeah.
And so that's all I had. One last thing, I'm sorry, that's not all I had. That's all I had on those things. Next week, planning on taking up H627, which is victims' rights of notification and the like in forensic proceedings on Tuesday and Wednesday. Part of I wasn't planning on taking that up earlier, but I learned that some of the witnesses that we would want, some victims are going to be in town at the State House on Wednesday for an afternoon public, I don't think I'd call it a hearing, but like a panel that the Lieutenant Governor is holding. And since they're coming up from Bennington to be here and from other places, I figured that we would start on that bill because it's relevant, absolutely relevant to the concerns that are being expressed there. So we'll do that on Tuesday and Wednesday. And I think we're going to be getting to the voyeurism bill on Thursday and Friday.
Is that 627, you said?
627.
That's something you're planning on bringing up at some point this year anyway.
Yeah, I think that was the plan, was to look at it. And so Kelly, what's Kelly's last name? Anybody remember off the top of my head? Who's been an advocate for this for a long time, has testified in here a couple times. We're gonna have her in and probably.
One we had yesterday?
No, it's
The one from Brattleboro, Bennington.
from Bennington,
was
from
murdered.
Bennington.
Anything.
Anyway,
Oh, and that's okay.
Anyway, Kelly. So that's what, if people want to look at that in advance, that's what we're gonna take up. Anything else? All right, we're wasting all this good time that we could be working on stuff.
Yeah.